The love fest over there. All right, good afternoon, everyone. Today's Tuesday, March 28th. We have how many bills in the docket? 1, 2, 3, 4, 5, 6, 7, 8. 11 bills on the docket. We're going to start off with House Bill 34. We'll then go to 52, 105, 151, 287, 331, 434, 833, and 1174. So we'll start off with Delegate Hill with House Bill 34. Welcome.
And thank you, committee members, Mr. Vice. Okay, Mr. Chair and committee members. So House Bill 34 is a bill that essentially allows for shielding of records for someone who goes to an eviction court, but there's no finding against them. Right now, if you're taken to eviction court, it doesn't matter whether there's a finding against you, whether you're evicted or anything, or whether you work things out with the landlord, or if the landlord's at fault, or if the landlord is simply using it as a leveraging weapon. In any case, you get labeled the same way. And frankly, this bill is just designed to say that if you are found responsible in an eviction court, those records should be known to anybody who's considering you in the future. But if the results are otherwise, that you shouldn't be labeled with that big scarlet E. We do have an amendment that we're asking you to put on the bill. We had changed the bill as it originally came in as a sealing of records to a shielding of records. And with that, we got, fairly uniform support. There is one on page 4, line 6, where technically that seal, changing the shield was missed, and we'd like that to be corrected. And so I would ask for a favorable report. We have the support of the Maryland Multi-Housing Association, the judiciary, and we also have the support of the Public Justice Center. And we ask that.
Thank you, Mr. Chairman. I think you mentioned the judiciary supports it.
Well, they're neutral. They had some issues with it, but they worked with us and when we changed it from a sealing to a shield.
Can you explain the difference with shielding and a shield?
So, yes, I'm sorry. Yeah, yes, please. I'm going to ask my colleague here to explain.
Sorry, I just never heard of those terms.
Yeah.
That term before, shielding.
Thank you.
Mr. Chair, if I may. Thank you so very much. There is the difference between sealing and shielding. Currently, when the bill came in, it was seal. Now it's shield. If there is a request for information on the information that's sealed, then the original judge would have to release that information if it's necessary. Under the shielding, when someone asks for it, it goes through the judiciary system and not the original judge.
I like the concept and the idea. Thanks for explaining.
And that's my subcommittee chair, Delegate Holmes.
Yes. No, originally I thought it was because we're familiar with like case search. So I thought the shielding dealt with case search.
Correct.
But sealing is like sealing of a record, which is like more of a records inspection at the courthouse. But all right, Senator West and then Sidnor, did you have a question? Oh,
thank you, Mr. Chairman. So thank you, Delegate Hill, for coming here with this bill. I think this is the first time you've been before us.
Nope. You sit on many of my bills.
Okay. Well, it's nice. It's nice to see you. The bill has an unfortunate title. It includes the words prohibition on rent increases. Is there anything left in this bill after the amendments in the House which would fall into the category of prohibition on rent increases?
Yes. So what it does say is that a landlord may not increase a tenant's rent solely due to a finding in an eviction court. Prohibits a landlord from increasing a tenant's rent solely because a judgment was entered against the tenant in a failure to pay rent. And I think, and again, we didn't really have any opposition about that because there are usually other reasons. What we're trying to do is to allow people to be able to move past bad actions that are often due to financial constraints or other situations. And there's, as you know, there's a range of reasons. And in people who are repeat offenders who are always paying late, all right, sometimes it's a matter of they pay late because they get their check on the 15th and they've asked the landlord if they can adjust their date and the landlord won't adjust the date. What we hear nationally is that landlords who have consistently late paying tenants actually get additional income because they get the late fees. And in many cases, it's preferable to keep a consistently late paying tenant than it is to go look for a new tenant who may not pay at all. So what's being captured currently are people who are well-intended, either have an occasion where they fall behind or they have a once or twice and situation, but they remedy that. So the landlord's made whole, but they're still being caught up and being labeled the same way as someone who really doesn't pay at all and that the landlord has to go through a lot. So the landlord can still raise the rent if they're raising it on other people, if there's a cost of living increase, if it's, you know, for any other reason. They're just saying that you can't solely do it because of this. And I think I also had information uploaded, a recent article that talked about how there are bad actors out there. And we've had some prosecutions in this state where some of the larger landlords who have multiple units will use an eviction filing because it's so simple to do as just a leverage to move things along, and they don't actually plan on carrying through, but they're causing difficulties for these folks.
Okay, so the only place I find the reference to prohibiting rent increases on page 2, I think I understand that. That's the
Yes.
solely language you just referred to.
Correct.
And then I was looking at the long list of witnesses over in the House, and there were a number of unfavorable, including the Maryland Building Industry Association and the judiciary. But what you're saying is that because of the amendments that were adopted in the House, those
Right.
unfavorables have been withdrawn.
Correct. Mostly neutralized. I think there may be one group that still has some issues, but they said that they are not going to aggressively pursue that. And we do have representatives from the multi-housing association here who, it wasn't just the ceiling bill, there were additional amendments that they put on to make sure that escrow proceedings wouldn't get caught up in this and that they could have access to the records that they need to do what is appropriate for their tenants.
Well, thank you for your answers to my question.
Landlords. All right, thank you.
All right, seeing no more questions, I thank you very
Thank
much.
you very much. Ask for a favorable report.
All right, next we're gonna hear House Bill 52, Delegate Foley.
Good afternoon, honorable members of the committee. And as you can see, I'm not Delegate Foley. I'm her chief of staff. Delegate Foley is in EEE right now testifying on another bill. And she just asked if you prefer, she could go last on the docket. And then if you have questions, you can ask her. Otherwise, I can present the bill to the committee.
Please go ahead and present.
Present? Okay. My name is Petra Smeltzer, and I'm presenting on behalf of Delegate Foley, House Bill 52, Condominium Sales Contracts Asbestos Disclosure. And this bill seeks to ensure that home buyers receive information about the presence and abatement of asbestos in multifamily housing. This bill would require a notice in a condominium resale contract that the owner disclose asbestos abatement within their own unit, but only during their occupancy. So right now, the owner is already required under the Real Property Article 10702 to state whether asbestos exists, but it doesn't require disclosing whether asbestos has been abated. And that seems to be kind of missing in the real estate contracts. So HB 52 has received broad support. It overwhelmingly passed out of the House Economic Matters Committee with broad bipartisan support, and then passed with a unanimous vote of 135-0 on the House floor. It is also supported by the Office of Attorney General, Maryland Realtors, and CASA. I can go on and describe to you why we believe that this is needed. It relates to the proven impact asbestos has on human health and the environment. As we all know, For decades, the US EPA and the Maryland Department of the Environment have documented these impacts. But you might be surprised to know that according to the US EPA, federal law does not require a seller to disclose to a buyer that their home contains asbestos or vermiculite, which is what asbestos is, a mineral used in construction that contains asbestos fibers. In the context of real estate contracts, if you have looked at older properties, finding out about an asbestos remediation on the property late in the real estate transaction could have consequences and could jeopardize the completion of the transaction. House Bill 52 would ensure that any asbestos remediation be disclosed and made available to any potential purchaser of a condominium dwelling. I could go on about in the background on asbestos, but I think everyone in this committee is aware of what asbestos is and its harmful impacts. So I'm just going to skip over that and then just go to what HB 52 requires. So the first requirement set forth by HB 52 is a statement indicating whether the seller has actual knowledge of the presence of asbestos on the site, including a description of the location of the asbestos, whether abatement has been performed, and the date of such abatement. This is what we consider a common sense requirement that all potential buyers and current residents of condo properties would appreciate. And the second requirement is the same, and it pertains to us to whether the council of unit owners in a condominium development has actual knowledge of the presence of asbestos on the site, including a description of the location of the asbestos, whether an abatement has been performed, and the date of such abatement. So to ensure that HB 52 does not conflict with existing regulations, the language of this bill was shared with Maryland Department of Environment. Asbestos Division, which determined that House Bill 52 does not add any remediation or abatement requirements to the existing state and federal regs. MDE has been regulating asbestos since the 1980s. So following recent news reports of catastrophic failures of condo associations in other states to identify and correct unsafe conditions, this simple notification requirement will help keep condo buyers in Maryland safe from the serious effects of asbestos exposure. So Delegate Foley urges a favorable report of HB 52. Thank you.
Thank you. Are there any questions, Senator West?
Thank you, Mr. Chair. I see that in the list of witnesses in the House, there was one unfavorable signed up. That was Mr. Wiggins. Can you remember why he was unfavorable, and has his objection been dealt with?
I don't believe Mr. Wiggins actually testified.
Oh, okay.
I think sometimes people, they can list their position without actually testifying. And I believe that Mr. Wiggins did not testify. I don't believe so.
Okay. Thank you very much.
You're welcome.
All right, seeing there are no further questions, we're going to end the hearing for HB 52. Thank you very much.
Thank you.
Next, we have House Bill 105, Delegate Holmes.
Thank you much, Mr. Chair, members of the committee. It's good to see you all here. I recognize that, like me, most of the members are jockeying back and forth between here and presenting in the House. HB 105 being presented to you is a bill that is a pretty simple bill and does three things primarily. First off, the bill talks about when a member of the homeowner, a lot purchaser, can become a member of the board. And the second thing it does, it clarifies how many annual meetings there must be, in that minimum of one annual meeting. And the final thing that it does is that it talks about and specifies when bonds are released, that the members of the common ownership community must be notified that the bonds are being released after the declarant has completed their construction. And that's all that this bill does. And unlike the previous bills that I presented in here last week, this was voted unanimously within the House of Delegates. And there was no opposition, not even one. No.
All right, are there any questions? All right, seeing them from this committee, I do just want to make sure and I heard you correctly. Did you say that it affects, I guess, in terms of governance, who can be on,
I'm sorry?
who can be on the board?
Oh, yes. Currently, when a declarant or a developer is constructing a project,
Mhm.
there sometimes is not someone that is a lot owner or a unit owner that is on the board with the declarant. And that sometimes causes a historical vacuum when the lot owners and the unit owners take over. So all this is doing is requiring at a 25% sale timeframe that one member of the population, one member of the citizens are to be on the board with the declarant prior to them transitioning from declarant control to homeowners control. That way, at least one member has intellectual history going forward.
Helps with the continuity.
That's indeed.
Appreciate it. Any other questions? All right, if not, that will end the bill hearing on HB 105. And if you can, Delegate Holmes, since we have you up here, would you mind doing House Bill 833?
I would appreciate that. Thank you so very much. I was hoping that you would accommodate me on this. HB 833 is a bill, and what this does is it prohibits someone in a common ownership community from their voting rights in the common ownership community if there has been a lien placed against that person. They can release, if they release the lien, then their voting rights are given back to them. So if they're in an HOA and they have sufficiently fallen behind in their assessment payments, they are no longer eligible to vote in the HOA until they have paid their assessment and got the liens released to give them their voting rights back. That's all this does.
Any questions from the committee? If not, I have just one question.
Yes, sir.
Would that affect the quorum for that organization? If they're not unable to vote, I would assume, could the organization still count them for quorum?
That's a very good question, Senator. If the person that has had the lien placed upon them is a board member and their voting rights are taken away from them, that may in fact present a problem where the board does not have a quorum. However, there are other provisions in the law, 11- and 11B- whatever it is, that provides for the board of directors of both the common ownership communities in general to have emergency meetings to then get the board members back up to quorum level. So there are other provisions already in statute that takes care of that.
Thank you very much.
Yes, indeed.
I see no additional questions. That ends the hearing for House Bill 833. Thank you very much.
Thank you.
Next, let's see, is Delegate Wells? Did I see? Okay, very good. House Bill 151. I understand you have a witness, so you can bring your witness up if you like. And if you wouldn't mind standing at the podium so we can catch you on.
Yeah. For my close-up, awesome. No. Good afternoon, members of the Judicial Proceedings Committee. For the record, I am Delegate Melissa Wells. I'm here to testify on House Bill 151. Further, House Bill 151 is legislation that my constituents have been asking for years, as well as being a priority bill of the Legislative Black Caucus of Maryland. Originally, the concept was to create a statewide rent stabilization bill because my office was getting calls consistently around extreme rent hikes. Tenants were not given the proper notice to make the decision on if they could afford the rent increase or if they needed to find a new living situation. And so out of this, this often was resulting in eviction. So out of this, we've now gotten to where we are now with House Bill 151, which aims to accomplish what it aims to accomplish is to give tenants that time they need to make the decision that works best for them and their families around extension of their lease or non-extension. House Bill 151 as amended would require a landlord to give a 90-day notice of a rental increase to a tenant or for tenants with lease longer than 1 month, 60 days notice for tenants with lease of 1 week, but no longer than 1 month, and 7 days notice in a lease of 1 week or less, or 21 days notice with a written lease. I want to make it clear that these notice periods do align with the already existing lease non-renewal language. In addition, the legislation would require reporting requirements in jurisdictions that adopt a local law to limit the rent increase that a landlord may charge a current tenant for a subsequent term without a gap in tenancy. However, this provision does not apply if there is a designated state of emergency by the governor or head of the executive for the local jurisdiction, and if the housing is funded in whole or in part by the local jurisdiction. I've worked with advocates, stakeholders in opposition to craft this bill and to amend this bill, and I do understand that there are additional amendments that they would like to see. I'm aware that these amendments would like to strike the non-preemption language, and another would be to make the reporting requirement statewide as opposed to limiting to those passing rent stabilization measures. I defer to the wisdom of the committee on these potential amendments, but I'm happy to answer any questions or continue the conversation offline so that we can pass this much needed legislation. And it is with that I ask for a favorable report on House Bill 151. Thank you. I guess so, yeah.
Right. Good afternoon, members of the Judicial Proceedings Committee. For the record, my name is Michael Donnelly. I'm from Economic Action, Maryland, here in support of House Bill 151. And so my day-to-day work involves a lot of speaking with property owners and renters about problems with the landlord-tenant relationship, problems with their housing. And, during this legislative session, I've been hearing a lot about this affordable housing crisis, and I hear a lot about it on the phone at work as well. And so one very serious issue that tends to come up a lot in the past few years is where renters don't necessarily know or have that much time to understand how much a rent increase is going to be. So they might get a notice or they might know that like a renewal is coming up, but then they're shocked to see that now they really just cannot afford the place that they're living anymore. And so what this ends up doing is it creates chaos in their lives. Like they don't have that much time to make alternative arrangements, or they'll be forced to sort of just accept to stay and pay an unaffordable rate of rent, or shift to maybe a less secure type of tenancy at even higher fees. And so, why I support this bill and why my organization do is because we believe that providing more notice and adequate notice so that renters have a greater understanding of what they're facing will give them a lot more of an opportunity to make alternative arrangements or sort of, make sure that these rent increases don't create as much chaos in their lives and lead to having to shift school zones in the middle of the year, live in housing that is really just inadequate where too many people are living in one room. And by simply providing more notice, we can alleviate a lot of the harm and we can, prevent a lot of the chaos that people are facing out there. And so for these reasons, I respectfully request a favorable report. Thank you.
Okay, Senator Washington and Senator West.
Thank you, Mr. Chairman. I do have a question about the study that's supposed to be done for 2 years of local jurisdictions that do have a local law that prohibits the increase of rent. Why? And why not jurisdictions that do not do it?
Yeah. So I think I'll speak to why it's there. But
I know why.
sorry. So I think the biggest reason is that there's concern that local jurisdictions are not oftentimes they make pleas at the state level for variances when it comes to development, what have you, but they're not necessarily, some folks feel like they may not be doing all they can to improve or help close a housing affordability crisis we have in terms of units. I definitely have no problem with seeing this done statewide because I think that we need to understand what's happening across the state. And so if it's the will of the committee to expand that statewide, I'd have no issue with that happening.
Yeah, because I mean, with the way it's written, it's with it has the connotation that capping rents is a bad thing, and therefore there won't be any new development that happens for those jurisdictions in a way it's written versus like these other places where there's no cap
Mhm.
and we don't see an increase in affordable housing for these other places. So
Yes,
just the way it's written just sounds
Yep.
like it's, so you
I don't
understand.
disagree with you.
Thank you.
Thank you, Mr. Chair. Thank you for bringing this bill to us. You mentioned in your testimony that there are some amendments. The bill that I have a copy of here, it was already amended in the House. Are there additional amendments that you would be recommending that we add to the bill? Because I can't find them in my packet.
Yes, so I was just kind of wanted to make sure I covered, I think, what will be following in some of the testimony. And also in conversations I've had with various advocates. So Senator Washington just spoke of around the extension of the study in terms of the permitting around affordable housing units. The idea of expansion of that statewide, which I would be okay with, if that's the will of this committee. And the other one is in conversations with the Maryland Multifamily Housing Association around preemption. There's a piece in the current legislation that states that which was added as an amendment, which states that this could not require, basically, if a local jurisdiction's rent increase notice legislation exceeds what the state requires, that the legislation would not preempt them. And so there's some appetite, I think, to perhaps have the state preempt it. I think maybe it would be best if we just stay silent on that aspect to not get into a war with Mako potentially. So those are the two amendments that I'm aware of, unless there's more that are out there that you might hear from or the folks that will be following me.
So maybe I missed it. Are those amendments currently in the bill that we've
They are,
received from the
no,
House?
these are new amendments.
It would be new amendments. Do we
Correct.
have copies of those amendments anywhere? They're just ideas.
These are things that I think will be raised in testimony that will follow. And so I wanted to mention it now that I have an opportunity to address you all.
Oh, I see. So there'll be some opposing testimony or some.
I know there's favorable
with
with amendment. Yes, for
great.
sure.
Thank you.
Yes. Mhm. Sorry if that was confusing, Senator. If I confused you on that, that was not my intention.
All right, I just want to, and maybe if you can answer this, it seems Grayson Wiggins within our system, it says he's favorable with amendments on one, and then he's unfavorable on another. I mean, okay, all right, very good. Thank you.
Okay, no
Just got
problem.
the clarification. All right, this ends House Bill 150. Oh, I'm sorry. Well, thank you very much. Appreciate that. All right, please. Thank you.
Thank you, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. There may have been a discrepancy. We just want an opportunity to speak. MMHA's position is technically favorable with amendments, but the bill didn't have a cross file, so it has not had a hearing here yet. So the clients want an opportunity to quickly speak. Just to provide some perspective before I get into the amendment, my understanding is the bill is 90-day notice for a year-long tenancy. Most of the states in the country actually don't have this law on the books. The ones that do, the vast majority are at 30 days. I can only find, I think, 4 or 5 states that have more than 60 days or excuse me, 60 days notice. And so this one's at 90. So I do think this would be one of, if not the strongest rent notice laws in the country if it's passed. And my client, in the interest of trying to be as reasonable as possible, is okay with the timeline. The issue is on page 3, lines 18 through 20, which says that the law does not affect or supersede any local law. And so my client's position is simply that if we are going to pass one of the strongest rent notice laws in the country, and if the state is going to step into the arena, that they simply preempt the locals from adding additional time so that we can have a general standard across the state that everybody can operate under and not have a situation where we have a patchwork across different county lines or even municipal lines. And so that's the amendment. That is the position my client has. And so that's just one opportunity to speak, Mr. Chair. Thank you.
So it's favorable with amendment.
Yes, sir.
Thank you. Any questions? Yes, Delegate Senator Kelly.
Every day, thank you. So just so I understand, because now I've gotten sufficiently confused, although the bill sponsor did a great job of answering Senator West's question. Is your position that you want to keep this language in, or that you want to have it clearly included, or you want this stricken, or you want a third path?
Our amendment is just to strike lines 18 through 20 on page 3.
And would that accomplish what the delegate said, which is be silent on this issue? I'm seeing nodding. I'm seeing nodding. Okay, perfect. Thank you.
All right, seeing no more questions, that ends the hearing on House Bill 151. Thank you all very much. Next, House Bill 287. Good afternoon.
Good afternoon, Mr. Chair. And hello, colleagues in the Judicial Proceedings Committee. I'm happy to be here. For the record, my name is Delegate Chris Fair, and I'm here presenting HB 287. HB 287 simply repeals the outdated and harmful law that criminalizes individuals for transferring HIV. There's been numerous amounts of testimony in your floor system that you can review in support of this repeal from various organizations, including MCASA, MedChi, the Maryland College of Nurse Midwives, Human Trafficking Prevention Project, the Harm Reduction Coalition, the Attorney General's Office, Lambda Legal, and I'll even mention the governor has commented on multiple occasions on the need to repeal this prohibition. There's a bunch of reasons in each of those letters about why, and I think that it's important to take a moment and recognize some of the key findings that you'll see in those letters about why this repeal is so necessary. And to me, there's 5 specific reasons that I want to highlight. 1, the law stigmatizes and decreases testing. I cannot stress that that is the most critical aspect of this bill. It seeks right now, with a current prohibition in place, people actively choose not to get tested so that they do not know their status, which is a critical step in the process of getting proper treatment and thus ending the ability of the individual to transfer HIV to another individual. Stigma around HIV has been in existence since the beginning of this epidemic. Our goal, our community goal, should be to end that epidemic. And to do that, we need to use all the tools in our tool chest to address the issues that stigmatize individuals from getting tested. Second, the law is inconsistent with public health recommendations. From MedChi to the CDC to my own Frederick County Public Health Department, letters of support have outlined that if we are seeking to create a public health outreach effort to end the HIV epidemic, we need to recognize how prohibitions such as this one, which is not commonly used and even less commonly convicted, help to stop individuals from getting tested, and after getting tested, getting on treatment plans. 3, the law is discriminatory, overly strict, and unnecessary. There is existing tools in a prosecutor's toolkit for when situations around HIV transfer occur. There is also civil law that can back up an individual's right to sue another individual if they end up testing positive for HIV. Maryland is the 6th strictest state in the country with its prohibition against HIV transfer. And HIV is the only disease that is called out specifically in criminal statute for transmission. Number 4, the science behind HIV has changed drastically in the last 30 years. Right now, if you test positive, you can be put on a once-a-day medication or a once every 3-month shot that will guarantee that you are what's called undetectable. Undetectable means you have a 0% viral load. So when you go to get tested, you'll still test positive for HIV, but it'll show that you do not have any active agent that can transmit. So when you're undetectable, you become untransmittable, which means you cannot, 100% guaranteed, cannot transfer HIV to another individual. So the goal should be to get people tested, to get them to know their status and get them on antiretroviral medication. That should be our public health goal that we have. Additionally, individuals who choose to practice unsafe sexual practices or go out and have multiple sexual partners and maybe are concerned about their health now have access to pre-exposure and post-exposure prophylaxis. A beta inhibitor that stops at an effective rate of 98.9% stops the active transfer. So an individual who doesn't have HIV, who might be concerned about getting HIV, has an active pill that they can be on as well. And then finally, the laws applied unequally and leading to more people of color and marginalized communities for being targeted. In the United States, Black Americans make up 13% of our population, but 54% of the people charged with this crime and 75% of all convictions. Women of color are mostly disproportionately impacted by laws like this that exist across our country. There is data and statistics on every single marginalized population that has been disproportionately impacted by legislation like this. So when taken in its totality, a law that stigmatizes individuals and discourages them from getting tested, a law that is inconsistent with our public health goals, a law that is discriminatory, it is overly strict and unnecessary. The science has changed massively around this issue since this law was passed in the 90s. And finally, a law that unequally and impacts disenfranchised communities are all the reasons I ask this committee today to support and give a favorable report to HB 287. Thank you so much for your time.
Thank you. Are there any questions, Senator Folden?
Thank you, Mr. Chairman. Delegate Fair, thanks for stopping by the office earlier. Thanks for bringing this bill forward. I've heard what you said about transmission, 98.9% effectiveness on the transmission of things. But as we discussed earlier, there was this very specific case that occurred in Frederick County where a person knew that he had HIV and he purposely, and with malice of intent, went out and had intimate contact with other people passing this along. I guess my question to that is having been someone that's been bitten by suspects, which is one of the things you brought up in my line of duty, and knowing about that specific case from Frederick County, I guess that's where I kind of have some hesitation about moving forward with something like this. I'm looking at the map that your office was great and sent over, and I see that a large swath of the country still has these measures in place to ensure the safety of their citizens. I understand the idea that you're coming forward with about, trying to get more them needed help and the trust in it. But there's also still the public safety side of it and maybe you're correct. Maybe some of it is the idea that there's fear, uneducated fear, I guess, maybe, by some. But how does this affect, say someone does get it transmitted to them, how does having HIV does it affect your ability or your fees if you try to get life insurance then beyond that, or things like that? Like, I'm just curious because I know there's many factors that go into it. Like if you've had, if you have melanoma, skin cancer, it'll affect your ability, because then you're all of a sudden your rates are higher for trying to go. And if you haven't tried to get insurance. So I'm just curious how this plays out into other areas, and affects that, knowing that this is something you're wanting to, because I worry about the part of not only this, but just how it affects in a ripple effect outside of just trying to focus on this, because I don't know that I'm still, like I told you, I was comfortable with this at all. But I'm just curious if you looked into any collateral consequences other than, if it's passed along, then you got to go get medicine. And then there's other things that affect your other policies. And then, I'm just curious if there's a higher
So to be perfectly, to be transparent, I've not researched what the exact insurance policies are. The federal government has taken huge leaps and bounds to make sure that medication is actively available to individuals who take the time to get tested and identify that they have tested positive for HIV. I will mention that in this goal for public health to do the outreach that we are doing to get people tested and on proper antiretroviral medication, so that they can become untransmissible, that work all by itself will lower the number of people who have active infections in our country and will thus save both taxpayers' dollars, insurance company dollars, et cetera, across the board. So that from that end, I did want to make one other comment. The Frederick County case of Rudolph Jericho Smith specifically was charged with 2 separate charges in that specific case. They were charged with 3 counts of second-degree assault and 3 counts of knowingly transferring HIV. It's one of only 15 cases in the last 30 years that have actually led to a conviction for knowingly transferring HIV. This specific case, the person was charged and was convicted and then sentenced to 30 years with all but 9 years suspended. The maximum charge or conviction sentencing for just the second-degree assault is 10 years per charge. So the individual just on the second-degree assault all by itself would have been charged for 30 years.
Provided that you're able to show that that's an assault, whatever that assault was. I don't know the circumstance around it but the part about in the language of this, it says that this bill is to repealing the prohibition on an individual from knowingly transferring or attempting to transfer the HIV virus. I mean, this is showing that they have an intent and you're wanting to repeal that.
So using your example of the individual from your case, I just want to make sure it's crystal clear, and I appreciate you taking the second to highlight the case because it gives an opportunity to help explain. It really doesn't matter that the person had the intent. They knowingly have HIV. They are having sex with another individual.
No. It says it's knowingly transferring.
That's what I just said. They knowingly.
No, knowing you have it and knowingly transferring it is the difference.
Again, having sex with an individual is knowingly transferring.
Correct.
And it has been used to apply to people using condoms. It has been used to apply to people who are trying to practice safe sexual behavior.
Right.
But the point is that it doesn't say.
So are you knowingly transferring it or attempting to transfer it if you engage in a sexual act with them with contraception?
Period.
With contraception?
Yeah. Yes.
Even if you're protected?
You are because you have it and the opportunity for transfer is there.
And that's because the other person doesn't.
My point is the statute does not specify or break out your scenario.
The intent?
It doesn't.
So.
Yeah.
So by your statement, you're saying that even though you use contraception and that it would not meet or that it would still qualify under this current statute? Yeah, condom, I'm sorry.
Yeah.
Sorry. Yes, thank you.
Thank you. I was going on the condom rule too.
And then the transferring, the knowingly part is the part that I guess where I'm kind of hung up on, because knowingly, if you let the other person know and they engage in that, then it's consensual.
Technically, the law does not, the way this law is written does not specify that. The individual could make the argument, I told the individual I have HIV, they were of equal risk, but the way this current law is written, it does not specify that specific scenario.
Okay.
Yeah.
All right.
Thank you.
Thank you.
I really appreciate it, Senator. Thank you.
Senator West.
Thank you, Mr. Chair. So if a man gets HIV, doesn't something happen to his body which would, if he's a thinking person, suggest to him that there's something wrong? I mean, if I did get COVID last summer and I knew there was something wrong, I felt sick, so I took a COVID test to see whether or not. If a person gets HIV, doesn't the person who gets it realize that there's something wrong going on with his body?
They can, they absolutely, and it will show up no matter it. The time length with which that you begin to show signs of illness can vary heavily from individual to individual, which is really important to note. But much like any other disease like syphilis, it can carry on for years without you being really acutely aware that something is happening, which is also particularly dangerous because you want to catch HIV early. So a lot of our public health efforts are to encourage active, consistent testing to catch people who maybe aren't necessarily feeling it yet, but need to get, but then find out that they're HIV positive and can get on antiretroviral medication.
And if you're engaging in that sort of sexual conduct with another man and you start to feel odd, I would think that the first thing that would come into your mind is maybe I've got HIV. Wouldn't that be the case? And I should either be concerned about it or should get tested for it, one or the other.
I don't want to purport on what other people would think. I would say that it wouldn't be necessarily the first thing that would pop in my own personal mind, but I'm not going to speak for everybody. And I would say that certainly people do have concerns around HIV, but it doesn't run the day-to-day lives and decisions, every decision that every individual makes.
Okay, well, so I'm looking at the language of the bill. It says an individual who has the HIV virus may not knowingly transfer or attempt to transfer it to another individual. If I had any suspicion, if I was engaging in that kind of conduct, and I had any suspicion that I had the HIV virus, it would be monstrous for me to have sex with another man and transmit. And as you said, having sex, whether you use a condom or not, transfers the virus. Absolutely monstrous. So don't you agree that that's the case?
I believe
that any responsible human being would not want to transfer this virus to another human being?
I believe that all people should be treated with respect and equally, especially in the conversations when you as an individual choose to have a sexual partner. I'll mention this isn't just a disease that's transferred between men. It's a disease that is transferred between men and women, women to men. It can be transferred in straight relationships and gay relationships, etc. It is, I think that the critical aspect to understand here is that the current prohibition outlines that this one and only disease is called out specifically in criminal statute when there are numerous other diseases that can kill you when left untreated, like HIV can kill you if left untreated. It can cause lifelong health effects. You can have public things like herpes can cause, obviously very obvious outbreaks and sores throughout your body. Syphilis can kill you when left untreated. Gonorrhea, and the list goes on, including coronavirus disease, which left untreated can kill you.
Well,
and so this one, HIV, is all specifically called out independently, which is inherently one of the largest problems when there is already a communicable disease statute on the books.
Well, as far as I'm concerned, I'd be happy to add coronavirus and some of these other ones to this list. I mean, I'm not sure the answer is to have no list at all, but to put all diseases on the list, which are communicable, and it would be monstrous for the person who has the disease and knows he has the disease to intentionally communicate it to someone else. When my son got coronavirus, I said, go back to your apartment, close the door. I'll live there for what I think the recommended time is at least 5 or 6 days, and then take another test. And don't come out until you're no longer going to have any chance of infecting someone.
And Senator, I really appreciate those comments. I'll mention section 18601. This is section 18601.1, but section 18601 highlights exactly what you're talking about already.
Okay.
This is a subsection of an existing statute that says you should not knowingly transfer communicable diseases to each other. That is punishable by 1 year in prison and I think it's $5,000 fine. Pardon me if I get the fine number wrong. Then the statute continues to call out this and only this specific communicable disease for special prosecution, which should give all of us pause. Why are we calling out one and only one specific disease?
Okay, that information is very helpful.
Thank you.
I need to go back and take a look at section 18-601.
Thank you.
I think that anybody who intentionally communicates any disease to someone else ought to be held accountable.
Thank you. I really appreciate that,
thank you.
Senator. I agree with you. Thank you.
Senator Kelly.
Hi, thank you so much. Thank you for this bill. I'm getting a lot of texts on it as well as we're having this conversation. So my question goes back to actually your original testimony, and thank you for bringing the bill. And I appreciate the intent of the bill, and I appreciate the idea to not single out one particular disease. I think that's really important. We don't want to create this sort of discriminatory impact. To Senator West's point, as he's up, I would draw your attention to the bottom of the MCASA testimony that points out that 18601 does not capture the direct intent to harm via infection, which I think is the question that Senator Folden was raising. And that they recommend that while they do not oppose repealing this section, that in the future, we should explore options to address how to criminalize contact with specific intent, which I do think is important. So it's a two-part question. The first part is, do you have a response to that testimony? Second part, totally switching gears. When you introduced the bill, you said that you had evidence that this current statute or statutes like this across the country disproportionately impact women of color. But you also said there's only been 15 cases in 30 years. So I'd like some more information on sort of what it looks like in Maryland in terms of enforcement, and if there's a discriminatory impact, and also any comment you have on the MCASA suggestion that we address this with this repeal, but also in a different way, the specific intent issue that's been raised.
Thank you. I appreciate that. And I want to cut to the first question. I might have to go back and ask you to repeat the second question just because I had my brain stuck on the first question. MCASA I've been working closely, my office has been working closely, and the advocates have been working closely with MCASA to address their concerns around intent. We have the executive director and others at MCASA have agreed that the best path forward is to repeal this piece of legislation, and it's not my word. You can go back and watch the House testimony as the executive director spoke on the behalf of MCASA about this bill. Repeal and then go in and address exactly what you're talking about, which is that intent piece. I have offered to assist in that process. My office has offered to look at the legislative remedies for the next legislative session to bring forward a bill that addresses that intent of passing any communicable diseases to other individuals outside of what already exists in criminal statute, which has to do with passing communicable diseases. That sounds a very weird sentence. Sorry. More data around.
Yeah, so you had mentioned that there is a disproportionate impact on women of color. You also mentioned there's only been 15 cases in 30 years. So I'm curious as to what that looks like.
Yeah, so some of that, I apologize, I didn't clarify. Some of that language is national statistics and some of that language is local. So just to kind of zero in on the local, by our count since 2000, this case, 150 of these cases have been brought up in Maryland, and only 13 of them had led to convictions. And so we're talking about a large number of, and this is something I need everybody to wrap their heads around. Individuals living with HIV are getting charged with a very public, very loud announcement that they have HIV to the general public, with a conviction rate of less than 10%. So these people are being drugged through the mud and being brought out in public, and then the convictions aren't carried forward. So my point to that was just simply pointing out how little this policy actually captures what we're trying to capture here. And how many people are actually negatively impacted because of the existence. Across the country, the data is a little bit different. The data, this policy in states that still choose to have HIV laws do utilize this prohibition more actively and aggressively, and that's where we get our national statistics. So let me read just from a few of the states which have who have taken the time to record this information. In 2021, 55% of arrests for HIV transfer were African-American in the United States, while only representing roughly 13% of the United States population. Black people make up nearly 3/4 of all HIV convictions in Georgia, which is one of the states that was studied. In Louisiana, Black women make up 4% of people with HIV, but are 21% of all the people convicted of this prohibition, while white women make up 40% of the population, but only represent 16% of those convicted and charged with the transfer of HIV. Missouri, 2020, Black men made up 5.5% of the population. They made up 35% of people living with HIV. And they were 55% of the people convicted with this prohibition. And it continues, Georgia, Tennessee, Missouri, Louisiana, all of these have taken the time to do the research. So I pulled that as national data so that we could understand kind of how this is negatively impacting, disproportionately impacting communities of color.
Great. Thank you very much.
Thank you so much, Senator. I appreciate it.
Senator Washington.
Just quick question. I appreciate the statistics around conviction versus non-conviction. Can those cases be dropped off of the case search, or can they be shielded? I think we learned another word called sealed today. Could they be, if they are not convicted, that they are sealed or shielded? I don't know if council knows the answer to that, or if
I don't know the answer to that question. I'm sorry. But I'm checking with my colleague back here to see. Do you know? Do you know? You don't know. Okay.
You're right, that's what I meant.
Are not expungible, can be shielded from case search.
Got it. Okay. Because I think that sounds like to resolve the issue of folks being, outed that they have it, but wasn't convicted, shielding it or at least removing it from case search so they aren't. It's just another route to get to where to get to one of the issues that you're trying to get at, which I understand the overall issue, but I just want to know the answer to that question. So
I appreciate it.
Thank you, Mr. Vice Chairman.
Thank you, Mr. Vice Chair, for helping to answer the question. Thank you, Senator.
Senator West, did you still have another question?
Yes, actually. Thank you, Mr. Chair. So I pulled out the code and took a look at section 18-601.
Yeah.
And what it says is an individual with an infectious disease that endangers public health may not willfully be in a public place without taking proper precautions against exposing other individuals to the disease. So if someone with HIV goes into someone's bedroom, that's not a public place, and sleeps with that person and gives them the disease, I don't think that situation is covered by 18-601. Do you disagree?
And no, I don't, but I'll say that neither is any other specific disease in that scenario is covered at all. And in fact, HIV is the only one that is now called out.
Well, we talked about coronavirus.
Yeah.
Now, coronavirus is transmitted by being in the presence of someone.
Yeah.
So that is covered by 18-601. Coronavirus is not particularly transmitted because you go into a bed and sleep with someone. It's just being in the person's presence that can lead to the infectious disease
in a
being transmitted.
In a public place, which to Senator Kelly's point, we were getting at drawing a specific piece of legislation to draw in the specific rules around intent. And that both this current prohibition in point 1 for HIV does not call out, as well as it does not apply to intent of transmittal of any communicable diseases inside of, to your point, outside of a public space.
But if we got rid of 18-601.1 and just were left with 18-601, and you had a situation of one person who went into another person's bedroom and slept with that other person and communicated the HIV virus, wouldn't it be possible if the prosecutor were to indict the person who infected the other under 18-601, wouldn't it be possible for the defendant in that case to say 18-601 doesn't apply to me? I wasn't in a public place. I was in a bedroom.
And again, that would be, I wouldn't pretend to be an attorney or a judge in that situation. I would say that the 18-6, if let's use your example and say that it is any other disease, period. 18-601 besides HIV, any other disease, period. In it using the exact same scenario, all I have to do is transfer any other deadly virus to this person in a private space, and I can't be held accountable to 18-601.
Well, that's what it specifically says in a public place, so I don't think it includes private places.
And that's why I'm agreeing with you. I believe that what we're trying to drive at here is separate from the repeal of a bill that targets and I think is misused to negatively impact certain communities. I believe that we can instead draw a piece of legislation after this is repealed to address exactly what you're talking about, what
I
you're
guess what
discussing.
I'm saying in return is I think anyone who intentionally exposes somebody else to a contagious disease and gets them infected, anyone ought to be prosecuted. And if what this bill ends up doing is exempting people with HIV who do it in a private bedroom from the general prescription against doing it in a public place, then we need to fix both 601 and 601.1 so that people with HIV are covered.
Yeah, I would simply respond and say that on the balance sheet, what we're talking about here is 18601 not only applies to in the bedroom, it applies to every scenario in which a person knowingly has HIV and has the opportunity to transfer it to them, because we can't get in their head. So we're just simply using the facts. When I met with a senator earlier today, we had a discussion about ways that this law has been very weirdly applied. So a woman breastfeeding her child, it has been applied to that scenario. A person biting a law enforcement officer during an altercation with no intention actually to transfer, just simply in the altercation because they knew it, knowingly had HIV. They had the attempt to transfer. The person, the law enforcement officer in that scenario, actually didn't even get HIV. And the person was still criminally charged for knowingly attempting to transfer HIV to a law enforcement officer purely based on the fact that they had HIV.
Okay.
And so that's an important distinction that I want to make sure I draw out.
Yeah, I appreciate this conversation.
Senator, I really do.
I think we need to do some work on this bill, but this conversation has illustrated the kind of work we need to do.
Thank you. Thank you.
That's okay. I already had a bite at the apple. No. Go ahead, Ms. Sidner.
Thank you.
Thank you.
And good afternoon. Question. So if this bill were to be repealed, I'm assuming one could still be charged with I guess a general assault statute. Would that be your
Yes.
understanding?
Yes, and that's a great, thank you, Senator. I appreciate you taking the time to point that out. As I mentioned in the Frederick County case, the individual in that case who did knowingly transfer HIV, got convicted for that charge for 3 charges, was also charged with 3 counts of second-degree assault. The individuals that were impacted by actually becoming HIV positive were open to civil litigation as well. So they were given the option through the court system to actually sue for the damages done to them. And in any one of the cases here that I have, there was a Montgomery County case from 2015. The HIV portion was dropped from the case. The individual was still charged with 2 counts of reckless endangerment and violation of probation. The list goes on and on. I'm trying to find Charles County. There was an example. The individual had 27 counts of sexual abuse of a minor. The transfer of HIV there was again dropped in sentencing. The individual was charged to 350 years in prison with all but 190 years suspended. I'm not sure why how that works, but they charged them to 190
So
years.
it sounds to me as if this act that I guess when the statute was passed is trying to be prohibited. We have other criminal tools to
Absolutely.
address.
Thank you. Yes.
The second question, I'm curious, in all of the stats you've been talking about, they've been criminal. I'm curious, do you have information about how the civil remedies have been used or in the state of Maryland? How often people have used civil action in order to
That is an excellent question. And if I had time, I could try to piece through my testimony here to see if there's an example. What I can do is my office can get it for you. I promise
Thank you
that.
very much.
Yeah, absolutely, Senator. Sorry, I don't have that on me.
Thank you. I don't want to go down too far down. I've become one of you all now. I'm going down the rabbit hole and I apologize.
You are now us, okay? So-
God help me. So I'm following Senator West's line of thinking. I'm cognizant of the MCASA testimony. I want to see us have that sort of the intentional piece addressed. I'm putting on my public health hat now from years and years of serving on the HGO committee. And I'm wondering sort of the cases you've gone through have been, clearly not related to sort of consensual relationships. The world has changed, right? I remember 1989 when this bill passed. I remember what the world was like. I remember the fear people were living in. I understand the intent behind the original law, although I don't think it's appropriate. That being said, now you have PrEP. Now you have at-home HIV. Like, I don't know about everyone else, but I entered the dating market and I was like, whoa, the world is different. You can go to CVS and buy a HIV test before you enter into a relationship at home in the privacy. It's a totally different world. So my question is, is part of obviously there's the singling out issue, which is really important, but also, and I'm thinking about this, if we were to go through the laundry list sort of approach that Senator West is talking about in correcting this, are people who are in consensual relationships worried that they might be charged because it's broad, the language is broad. And then if we were to include syphilis and herpes, like basically, is the law basically saying it's kind of illegal to engage in sexual activity if you have HIV? Is that basically the problem? Even if you're on medication, even if you are suppressed to the point where it's not transmissible?
There's nothing in the existing law that has a protection built in for any person making any extra effort to communicate with their partner.
Even if you've done everything right and they've made a conscious choice that they're in love with you and they're willing to engage, and whatever,
those protections are still not in place. And I at the beginning, I know I rattled off a bunch of stuff and I apologize for being so verbose about it, but I do want to cut back to one comment from the Centers for Disease Control and Prevention to your public health point. These laws, that is prohibitions against people living with HIV, these laws, this is a quote, have not increased disclosure. They have not increased disclosure and may decrease HIV testing, it does increase stigma against people living with HIV and exacerbates disparities in our communities. So the CDC has called this out with no questionable terms whatsoever, that this specific prohibition should be repealed and if need to be replaced to address intent issues, to the senator's point, I would be happy to discuss that as a separate piece of legislation.
And that maybe the statute should be really clear that it's the intentional, there are good people doing the right thing that we don't want to include, but obviously we definitely, like, if someone wants to infect me with herpes, I got a problem with that too. Right?
Yeah, thank you, Senator. Thank you, Senator. Great point. Always like to end comments on herpes.
Live from JPR. All right, Senator West.
This will be my last bite at the apple, I promise. But I'm picking up on that colloquy between Senator Kelly and you. So if I had HIV and I've taken the blockers so that I can no longer transmit it, or is it your position that this bill would still criminalize me if I had sex with another man? It doesn't look like it to me.
So
it says it may not knowingly transfer or attempt to transfer the HIV virus to another individual. So if I've taken the blockers and I've been told I would not be transmitting it, why would this bill cover me?
Because it does not specifically call out. The fact is you still test positive for HIV, even though you're untransmittable, but you still have the human immunodeficiency virus.
Right.
And it says you may not attempt to transfer. Attempt. It doesn't say you have to transfer it. It just says you may not attempt to transfer.
But if I've been told that I would not transmit the virus because I've taken the right prophylactics,
right?
How would my having sex with another man result in a prosecutor indicting me for attempting to transfer the virus?
That's a great question. I can't promise you that they would indict you or convict you. I can promise you that the bill does not, the current statute does not make that determination at all. It does not say just because you're on a proper antiretroviral therapy, that you cannot be charged for attempting to transfer HIV to another individual. It just doesn't say that.
I'm not sure I understand the logic of your argument, but I hear what you're saying.
No, thank you,
Thank
Senator.
you.
Okay.
No, I came in late. Thanks, Delegate, for the bill. My question was also similar to that. Just if you get to the point of undetectability, and that means, if that means that you have no longer the ability for transmissibility,
Yeah.
then how would this fit? Because you can't, are you incapable of transmitting the virus at that point in time? Because so would that fall under the current statute?
Yeah.
And I guess the answer is we don't know, but
Wait, we're not, I can't be
Yeah.
100% positive about how a court would rule on any of such nuance, but I will say that, again, the law as it's currently written says you have HIV and by knowingly attempting to transfer. It does not specify what knowingly attempting to transfer looks like.
but if it's an impossibility because you are no longer transmissible, that's the thing. But anyway,
Yeah.
How often has this been used?
So in the state of Maryland, there has been examples since 2000 of 150 cases that have been charged against individuals, and only 13 actual
Got
convictions
it.
since 2000.
Excellent. Thank you very much. Senator James, then Sidney.
Wanted to make a comment because when I worked for Judge Northrop, we had a very early case. It was either this or another disease. And I just want to tell you that just generally the common law on this is you do have to know that you're infected, and you have to, so and then you have to be reckless or knowingly try to transfer it. So with all due respect, I would have to look up the cases, but I can tell you that I believe the intent of the statute is that if you did not want knowing to be part of it, you would take it out of the statute. It would just be the mere transfer or attempt to transfer. So intent is important in this statute, but I think the best way for us to figure it out is to look at some cases that either in Maryland or in other parts, but I'm telling you that back in the 80s, we were dealing with this at the federal level, and the fact of whether you knew is so material to whether you're held responsible. So that's just generally what it's been since the 1980s, at least for lawyers in court.
So
Thank you.
Senator, it's funny that you said that, because we're arguing whether it is completing the act or transferring, you know what I mean? Did I'm saying like the sexual act, or is it the actual knowingly transfer HIV? Because if that's like, I asked the question about if you are not transmissible, will you
no,
still
we
get?
didn't even have that.
Yeah, I
option.
know.
So we didn't get into that. That's such a good question, but back then that was not the issue, but I get what you're bringing up.
And that is why earlier in my testimony, I mentioned that Maryland has one of the strictest HIV prohibition laws in the country. That is partially because of how this specific statute is written. It yields wide latitude of what the word knowingly means and how it's applied to each individual case.
I was just curious, in looking at the testimony that had been submitted to us, I mean, outside of the Office of Attorney Generals, I don't think that I see anything from state's attorneys or the public defenders. Have you had any communication with either of those offices about this legislation?
Thank you for the question, Senator. I have not had any conversation with any of the state's attorneys about this specific legislation,
Public
just with the Attorney
defenders?
General and with the governor.
And what about the public defender's office?
The policy, no, I'm sorry.
Okay, thank you.
Thank you.
All right. It's a long hearing for this bill. Seeing no further questions, thank you very much, Delegate.
Thank you.
Pleasure. Thank you.
Thank you, Senator. Thank you, Mr. Chair.
All right, so with that, that'll conclude the hearing for House Bills 287. We'll now go to House Bill 331. Delegate Ross is here. Delegate Charles, you're next. So I know you're hanging in.
All right. Hopefully this will be a little shorter. We'll see. Okay, good afternoon, Mr. Chairman and Vice Chairman and members of the Judicial Proceedings Committee. For the record, I'm Delegate Jen Tarasa. Thank you for this opportunity to present House Bill 331, which requires that virtual meetings of a governing body of a common ownership community, which I'm sure you know includes HOAs, condos, and co-ops, must include a reasonable opportunity for community members to participate in that meeting, including equal access to available chat functions. And the other thing that it does is provide that board meetings held by electronic transmission, including emails, are also subject to the open meetings requirement. Therefore, can only be closed, that is not available to the whole community for one of the specific purposes enumerated under Maryland law. So you may recall that the General Assembly passed legislation several years ago during the height of COVID that allowed governing bodies of COCs or common ownership communities the ability to use virtual means to conduct meetings. That was Senator Smith's, Chairman Smith's bill, and cross-filed by Delegate Holmes. That passed unanimously out of committee in both chambers and was enacted in June of 2021. While these types of meetings may have begun as a result of necessity during COVID-19 pandemic, it has become clear that they are likely to remain a regular option. And such virtual meetings are a convenient and effective way for people juggling all sorts of things, family life, work, et cetera. Over the past few years, I've heard quite a few concerns about how these meetings are being conducted, though. We've been told by a number of community members that COC boards have been using the chat feature and blocking people on chat, that they've been muted and not given an opportunity even to object to things like lack of quorum. And without the ability to participate in the meeting, their presence on a Zoom or other virtual platform is no different than merely watching on TV. Of course, we've all experienced or heard experiences when someone becomes disruptive in a virtual meeting. And that's why this bill also provides an ability to mute participants if they become disruptive and are provided a warning. So HB 331 would basically clarify some of these best practices. In terms of the email meetings, the modern world's basically, involves constant electronic communication. I'm sure you guys are all very familiar with that. And during the height of COVID, this became even more frequent. In fact, a lot of conversations were taking place among the board members as well as decisions because it was an emergency, it was necessary. And that same thing, this poses a problem, though, as an ongoing means of communicating business because COC boards meetings should be transparent to the community, represents by providing opportunity for resident participation. So this makes clear that those email discussions actually are considered meetings, which must be open to the community. If they are held without notice and the ability for the community members to participate, they're considered closed meetings, and that can only happen legally for one of the purposes enumerated under Maryland law. In my written testimony, I've given you a number, I'm sure you're familiar with them, but they enumerated the legal reasons that they can be closed, including discussions of employment, consulting with legal counsel on legal matters, discussion of individual assessments. So we worked out an amendment to address confusing language in the original draft, and there's no opposition to this bill, which passed unanimously on the House floor. And HB 3031 increases transparency. It makes it easier for community members to fairly participate and protects rights of residents while allowing COCs to take full advantage of modern technology. I respectfully urge a favorable report.
All right, questions from the committee? We have one from Senator McKay.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill. So my question is, people who are on the Zoom, what is defined as reasonable opportunity to participate?
Right.
Is it the same as Delegate Charles just sitting there and deciding he wants to participate in what we're talking about here? Is that is that the freedom, or is there Robert's Rule of Order or Mason's Manual? Or
Many boards use Robert's Rules of Order, some don't. Lots of boards have different times at which a person can participate. But one of the reasons I thought this was really important is if we're sitting in a board meeting and there's no quorum, somebody can stand up and say, wait, you guys can't get started. There's no quorum here. That might be a way to participate. There's other, I believe there, and I'm sorry, I don't remember this off the top of my head, but I believe there has to be some resident speak out of some sort. I don't remember that right off the top of my head.
Your intent is to have guardrails, just not automatically people speaking.
Yes.
And the reason
Yes.
I had a bill for county commissioners
Okay.
to use Zoom in emergencies only, and it would be no more than 2 meetings in a row.
Yes,
And
I
we
saw
had
that.
some
Yes.
people wanted to participate during the whole, not at the time for participation of visitors, but Senator
Right.
McKay, why did you vote this way? They wanted to have that interaction. I just want to make sure that this is not
No. I really appreciate the question. So first of all, this isn't an emergency. This isn't for emergencies. This is for always, but to
Understood.
your point, I'm not intending to give them any different right to participate that they wouldn't have if they were sitting here like,
Perfect.
right? That's it.
That-
I
that
just
address-
want, if you're going to continue to do your HOA meetings virtually, that they are as similar to virtual meetings as you can make them.
Okay.
I mean, to in-person meetings, sorry. Yes, thank you.
That satisfied answer. Thank you, Delegate.
Well, thank you very much, Delegate. Questions? Seeing none, thank you very much. And with
Not
that.
insulted. I hope my bill was just as interesting as the last, but
Yeah.
hopefully you'll consider it. Thank you.
We will. Thank you very much. It's good to see you, Delegate. All right. All right, with that, that'll end that bill, the hearing for House Bill 331. We'll now move on to Delegate Charles at House Bill 433. Welcome.
30 seconds. I'll try. All right, good afternoon, everyone. For the record, I'm Delegate Nick Charles, and I'm here on behalf of House Bill 434, Maryland Condominium Act Amendments to the Declaration. This bill came because of issues with some of the condos and folks that I know living within condominium communities. They share the same exact they may share the same exact fee when it comes to the trash, when it comes to security for the building, when it comes to water a lot of times. But the actual cost of the condo fees are broken down based off of the size of the unit. And so the issue with that is you may have someone with a larger unit who is paying way more in condo fees in comparison to someone with a smaller unit, but they're actually using less water, using less trash. So in order for them to make a change to the condo fee structure, they have to make a change to the declaration, and that's an amendment to the declarations. Currently, you need 80% of the community to actually vote on those declaration changes. That's a hard issue to get past. 80% of the community. You can barely get 10% of the community to show up to any of the meetings. And so 80% has been a large issue. And so after working with Delegate Marvin Holmes and his subcommittee, we landed on 66 2/3%. And that is also what's needed to change the bylaws of HOA documentation as well. This bill is an enabling bill. It doesn't automatically go into effect. But what this does is it allows for the HOAs to call for a vote. And as long as they have 66 2/3% of the owners, that can now go into effect. There was one amendment that was made to the bill on the House side, and that bill amendment was after talking with the developers. We wanted to make sure that the developers were completely out of the process. They had no more ownership of the units within the condominium dwelling. So this would allow for the community to make the decision themselves versus bringing the condo developer into the equation. And with that being said, I ask for a favorable report on this bill. And if you have any questions, I am here to answer.
Thank you. You had mentioned in your testimony that it's enabling. What did you mean by that?
So it doesn't automatically go into effect, the change of the condo fee structure. So in order to change the condo fee structure, they would have to vote on these, get the 66 2/3% vote from the community to then change the condo fee structure. So this bill, though it's specifically speaking to the amendments to the declaration, the end product of it is the change to the condo fees that are structured across the entire community.
Okay, because right now we're at 80%.
It's at 80%, correct.
Okay, so this would change it so it doesn't have to be 80, but you can have a vote, and as long as you got 66 2/3, then you're good.
Correct.
Okay, thank you.
Yes, sir.
Thank you, Mr. Chair. So the question has always been how long the developer keeps control. So when the developer sells one unit, so let's assume it's a 100-unit condominium, he sells one unit, the developer still owns 99 units and therefore would have 99%. And as I read this, what it says is the developers continues to have control, utter control, until the developers' units fall below 80%.
When it comes to changing the declaration.
Yes.
But right now, when you at least have 51% ownership, owned by actual residents and not the developer, that's when the residents take over the condominium association. But you cannot change the structure of the condo fees or the declarations to the amendments to the declaration until the condo developer is out of the picture. So even though there's 51% ownership by all of the residents within that particular community, and they are running the HOA or the condo association the way they see fit, they cannot vote to change the structure until you completely have the developers out of the picture, which is 100% ownership of the community.
Okay, well, I don't see that in the bill. It looks, you changed it to 66 2/3%.
Yeah, I'm sorry, 66 2/3%.
It's just not 100%. So the developer can still own 30% of the units. But if the private unit owners own 70% of the units under this, since they own more than 66 2/3, if they all got together and agreed on something, they could change the declaration, correct?
No, that's why I said specifically, if none of the units of the condominiums are owned by the developer of the condominium. So
Where does it say that in the bill? I just don't see it.
stand by one sec.
It says if any of the units are owned by the developer, the declaration may be amended only with the written consent of 80% of the unit owners. And assuming the developer owns the units, then you'd need 80% of the unit owners. If the developer continued to own 82% of the units, then the developer would totally control, right? I'm just confused.
I'm looking at it now. And I see where the confusion lies. If any of the units of the condominiums are owned by the developer, the declaration may be amended only when the written consent of 80% of the unit owners listed on the current roster.
Right.
And
So if the developer owns 82% of the units, then the developer controls and can change the declaration at will until the developer's ownership falls below 80%, then the developer would not have the 80%, and the private unit owners could block the developer in changing the declaration.
and
That's how I read it.
that is correct. Yes.
Okay, great, thanks.
Yeah.
Any further questions for the delegate? All right, thank you so much, Delegate Charles. That concludes the hearing for House Bill 434. We'll now move on to our final bill of the day. Delegate Fisher is here with House Bill 1174.
Last but not least, Mr. Chairman and members of the committee, before your House Bill 1174, it's a local Calvert County bill, civil infractions, prosecutorial designations. It just authorizes the state's attorney in Calvert, subject to the approval of the county commissioners, to designate in writing to the county attorney or to an assistant county attorney to prosecute civil infractions. And since Calvert County is one of only 6 counties that have a commissioner form of government, we have a mother may I form of government. So we have to come here and ask permission. So we're asking permission. Supported by Senator Jackson, supported by Senator Bailey, supported by the delegation. So, and the county commissioners. What a miracle. Everybody agrees.
All right, questions for the delegate? All right, thank you so much.
you.
Oh, Senator Sidner.
You have to explain this one.
Did Dwayne put you up to this? That's what I want.
No. I'm just curious. Why do you have to come and ask us this? I don't get it.
We're a commissioner form of government, so we have to, any power that's in addition to what they currently have, we have to come to the General Assembly and ask for it. So,
thank you.
Of course. Yeah. Exactly. Precisely.
Can we make the council form of government also do this mother man.
Which is interesting.
All right, thank you, Delegate. Really appreciate it.
Thank you,
That,
Mr. Chairman.
that concludes the hearing for House Bill 1174. And that concludes our hearings for today. Give us 1 second. We'll give you an update as to when we